Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. I'm going to read the first half of this statute because it's really long, and then at the end, I will discuss it. If you have questions, reach out to me directly. 25.318, disposition of property, retroactivity, notice to creditors, assignment of debts, contempt of court. A, in a proceeding for dissolution of marriage, for annulment, or for legal separation, or in a proceeding for disposition of property following dissolution of the marriage by a court that previously lacked personal jurisdiction over the absent spouse, or previously lacked jurisdiction to dispose of the property, the court shall assign each spouse's sole and separate property to such spouse. Except as provided in section 25.318.02, the court shall divide the community, joint tenancy, and other property held in common equitably through not necessarily in kind without regard to marital misconduct. For the purposes of this section only, property acquired by either spouse outside of the state shall be deemed to be community property if the property would have been community property if acquired in this state. B, in dividing property, the court may consider all debts and obligations that are related to the property, including accrued or accruing taxes that would become due on the receipt, sale, or other disposition of the property. The court may also consider the exempt status of the property, particularly pursuant to Title 33, Chapter 8. This section does not prevent the court from considering all actual damages from judgments from conduct that resulted in criminal conviction of either spouse, in which the other spouse or child was the victim of excessive or abnormal expenditures, destruction, concealment, or fraudulent disposition of community, joint tenancy, and other property held in common. The community, joint tenancy, and other property held in common for which no provision is made in the decree shall be from the date of the decree held by the parties as tenants in common, each possessed of an undivided 1/2 interest. E, the court may impress a lien on the separate property of either party or the marital property awarded to either party in order to secure the payment of 1, any interest or equity the other party has in or to the property, 2, community debts that the court has ordered that the parties pay, 3, an allowance for child support or spousal maintenance or both, 4, all actual damages and judgments from the conduct that resulted in criminal conviction of either spouse in which the other spouse or a child was the victim. F, the decree or judgment shall specifically describe by legal description any real property affected and shall specifically describe any other property affected. This section applies through both prospective and retrospective operation to property without regard to the date of acquisition. H, in all actions for dissolution of marriage, annulment, or legal separation, the court shall require that the following statement in the materials provided to the petitioner and to be served upon the respondent. The notice to creditors. This is long. See the full text for a copy. The link is in the bio. On the written request of any party, pending dissolution of marriage, annulment, or legal separation, the court, except for good cause shown, shall issue an order requiring any credit reporting agency to release the credit report as to the spouse of the requesting party on payment by the requesting party of any customary fee for providing the credit report. So this is a really long statute, but it is super important. There are so many provisions in here that protect someone who has been the victim, or a child who has been the victim of a crime against the other party. It allows someone to basically attach the property, let's say real property, for security of payment of child support or spousal maintenance. In a case where there is suspected fraud or bad action by the other party, you can actually directly ask for a credit report of that person, and by paying the fee to whatever company it is, Experian, TransUnion, you're going to be able to get a copy of that person's credit report. It's going to list out the debts, all of those things. So this statute is so important when you're going through a dissolution, that you review it and utilize all of the outlined provisions.